All right, so let's get started. What we're going to focus on this uh, session is this is going to be brief. This is going to be on dealing with um, credit loans or anything of that nature on the not just the civil side, because everybody's familiar with the civil side, Title 15, um, fair credit reporting, fair debt collection practices, uh, Truth in Lending Act, Real Estate Settlement Procedures Act. So look those up if you don't know, and then we're going to compare it. But what I'm going to do is I'm going to focus on a different approach. I think we should take in regards to dealing with some of these people because if you're what I've learned is if you're just dealing with the civil side of it, and there's no common law or no constitution base behind that, right? Even in within those times, they can wiggle around, due process, right? And they can just do these things based off technicality. Now, some of the quick thing about judges, right? When you bring your claim, right? If you bring your claim as a consumer or just as a man, living man or woman, claiming what has been violated or trespassed upon you, if attorney comes in against you with no verified statement from any individual within that company or whatever that entity might be, you already won, right? Because the only people that the only ones that can sue and be sued are real parties in interest, right? You got to have some type of um, interest in something. So if I'm the claimant, petitioner, plaintiff, whatever you want to call it, as bringing the claim, and I say XYZ entity or Joe Blow did something to me, and it's in the form of some type of violation, then I'm saying that that individual or that company has an interest. We have some type of agreement, right? So, with that being said, the only problem that you're going to have is the judge. Sometimes these judges aren't paid. Some of them might be indoctrinated. Some of them might be real weak in regards to their stance in defending the Constitution and defending equity in regards to contracts, so on and so forth. So they get their personal feelings involved. So what we can do on the next run, but you look it up, is look up judicial ethics, canons, attorney ethics, and then relate that to something in regards to what you can do behind that if they do violate that. I'm not going to get into that today because that comes later. We're dealing with outside of the court and then what we bring inside of the court based on the criminal matters of things. And we're just dealing with federal right now because all states are different. So let's just deal with the federal level then, but it's all uniform and it trickles down to the states. Now, we're going to get into, and all this is going to have to do with collections like debt. So all the things you hear people talking about, Title 15, so on and so forth. Let me give you another angle to look at. All right. So what we do know is what we have is what we call color of law, right? Everything is color of law. The Constitution is definite, has no color in it. That's the rule of law. When we deal with the color of law, um, we have something we could go into detail with that. I'm not going to go break that thing down, But when we deal with color of law, it's something that is presented as law, but it's kind of not actual law. Okay. It is to pose itself as something lawful, but it's not. So some of these codes, statutes and codes and things like that are utilized to circumvent the Constitution. That's why you have things like writ of prohibition, writ of mandamus. You also have where you have constitutional challenges to see if any of these codes that have been enacted by legislation on the state side or on the federal side are something that is intended to intersect or circumvent the Constitution. Right? A lot of people have gotten these agencies and departments and governmental entities have gotten lazy because they're relying on these codes and then allowing companies to dictate what these codes mean, regardless of if it's in violation of the Constitution or is going to infringe on somebody's constitutional protected rights. So, right. So here's a code that a lot of people might not be familiar with. Right. This is Title 42 USC 1994, peonage abolished. Right. Here it is right here. It says the holding of any person to service or labor under the system known as peonage is abolished and forever prohibited in any territory or state of the United States. And all acts, laws, resolutions, orders, regulations, or usages of any territory or state which have heretofore established, maintained, or enforced, or by the virtue of which any attempt shall hereafter be made to establish, maintain, or enforce directly or indirectly voluntary or involuntary service or labor of any persons as peons in liquidation of any debt or obligation or otherwise are declared null and void. So remember that. Now, if nobody's known about this code is basically saying that there was a time where involuntary and voluntary service was permitted in regards to payment of debt. So they can actually put you in voluntary or involuntary. You, you come peacefully or we'll drag you. Right. So directly or indirectly, it will be something that is to be um, considered null and void. So we established that debt has been established as voluntary servitude and peonage. So let's pause this. All right. So here, right? So as we were right here on the peonage abolished, right? So as we state right here, this is showing the um, fact that this peonage, these peons and all this stuff was actually used in the involuntary or voluntary uh, um, commitment or the voluntary agreement or involuntary agreement to provide a service or labor, right? And it was abolished. And all these things were done in liquidation of any debt or obligation, right? What I'm going to do at this point in time is um, um, I'm gonna stop sharing real quick. I'm gonna go pull this thing up. Let's go to we'll go to Article 3 of the UCC, right? You pull these things up. Now let me come back to the share screen. Let's go back to the share screen. We're gonna share that. And here's negotiable instruments here, right? So we're gonna go down here, right? And we're gonna talk about we're gonna go down here to uh we're gonna go to payment. Okay. So here's payment, right? So in payment, it states, right, subject to subsection B, an instrument is paid to the extent payment is made, one, by or on behalf of a party obliged to pay the instrument, and two, to a person entitled to enforce the instrument. To the extent of the payment, the obligation of the party obliged to pay the instrument is discharged, even though payment is made with knowledge of a claim to the instrument under Section 3-306 by another person. So, right here, to the extent of the payment, the obligation of the party obliged to pay the instrument. But if the obligation of the party is paid, who is it paid to? It has to be paid to somebody who is the one entitled to enforce the instrument. Okay, now we're going to go back and we're going to go to 3603. All right. So it says, if tender of payment, right, of an obligation to pay an instrument is paid to a person entitled to enforce the instrument, the effect of tender is governed by the principal laws. B, if tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge. Okay. Now, what you got to see in this matter is what is considered to be payment. Now, what is payment here? Let's go. What is payment here? Let's go to definition. This is the definitions regarding this article 3. They don't have a thing for payment, but they do have a promise. Promise means a written undertaking to pay money signed by the person undertaking to pay. An acknowledgement of an obligation by the obligor is not a promise unless the obligor also undertakes to pay the obligation. Okay, now hold on. Negotiable instrument, except as provided. Negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order if it is blah 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 blah. The instrument means a negotiable instrument. Okay. And it says right here a fixed amount of money with or without interest or other charges described in the promise or order. Okay. Now, everybody's under the assumption that money is what we consider to be money. So, just to put those things on your mind, do your own research. We're not going to get stuck there. All right. Now, what we're going to do is we're going to come back We're going to come back over here, right? Here where it says obligation, right? We got the obligation here. So even if you're obligated to do something, the onus, the burden of proof is on the person bringing the claim or trying to enforce something. They have to prove that they have the rights to title and have the right to enforce an obligation. Okay, we were just read. Now I'm gonna get you familiar with these, right? We'll come back to that. So we got 18 USC subsection 241, conspiracy against rights. Two or more persons conspire to injure, oppress, threaten, or intimidate any person, in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or two or more persons go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise, shall be fined under this title or imprisoned not more than 10 years or both. Okay. Aggravated sexual abuse or an attempt to commit aggravated sexual abuse or an attempt to kill, they shall be fined under this title in prison for any terms of years or for life or both, or may be sentenced to death. Okay. Still enacted. It's not repealed, right? This is conspiracy against rights. And everybody can, equate these things to just police and getting pulled over. But no, this actually goes into credit as well. These laws are in within. I'm going to show you real quick. Title 18, 242, deprivation of rights under color of law. Right? Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights or to different punishment, pains, or penalties on account of such person being an alien or by reason of his color, race, shall be fined under this title or imprisoned not more than 10 years. And the same thing as 241, if death results from acts committed in violation, kidnapping or attempt to kidnap, and we're going to talk about this kidnapping, aggravated sexual abuse or an attempt to commit aggravated sexual abuse or an attempt to kill shall be fined prison no more than 10 terms of years or for life or both, or may be sentenced to death. Now, how does this fit into consumer law? How does this fit into contracts and collections of debts and credit reports and so on and so forth, right? You got to deal with what is under these people are bonded and licensed to do a profession in the fiduciary capacity and in service of the people. They're middlemen, they're brokers. They have no rights and titles or anything. All they're doing is servicing these transactions to make sure the people, because the people are now insolvent or solvent from the fact of there's no gold and silver to utilize in the purchase and payments of debts, or so on and so forth. So they need these agents to come in here and be middlemen and servicers of these accounts because the United States government is now operating under a de facto sense, or what is considered democracy or democracy or a democratic republic, where now you have this corporation aspect to it, right? That is based off debits and credits, zeros and ones. So with that being said, these things go into place. Now, everybody knows Title 15, fair debt collection practices, as you mentioned before. But now we're going to give you some other ones. Okay. Now, this is 1028. Fraud and related activity in connection with identification documents, authentication features, and information. You go into the bank, And then you say, I need to get a car. They say, all right, we need to see if you qualify. We need your identification. We need to see your ID. We need to, your social security number. We need the date of birth, da, 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 da. Right? Why do you need this? Well, we need this to identify you. This is what they say. So look at this. Whoever in circumstance describes knowingly and without lawful authority produces an identification document, authentication feature, or a false identification document, knowingly transfers an identification document, da 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 da, knowing that such document or feature was stolen or produced without lawful authority, knowingly possessed with intent to use unlawful transfer, da da da, and so on and so forth, 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 and so on and so forth. The punishment for offense under subsection A of this section, 3 years, fine under this title, or imprisoned for not more than 15 years, or both. The production of or transfer of an identification document authenticates fears, false, that is, or appears to be an identification document issued by or under authority of the United States, or a birth certificate, or a driver's license, or a personal identification card. The production of more than 5 identification documents, authentication features, or false identification documents. Let's go back. The punishment for an offense, B1, except as provided in paragraphs 3 and 4, fine under this title or imprisonment not more than 15 years. B1A, the production or transfer of an identification document, authentication feature, or false identification document that is or appears to be an identification document issued by or under the authority of the United States, or a birth certificate, a driver's license, or personal identification card. B, the production or transfer of more than 5 identification documents. So what this is saying right here is that a false identification document that is or appears to be an identification document or authentication feature issued by or under authority of the United States. So they're saying that a birth certificate, a driver's license, or personal identification card are not considered, that's issued by the United States government, are not considered to be identification documents. All right. So you have these banks coming in here, or these people that are extending credit, you doing online or whatever. These type of credit card companies, they're telling you that the way they can identify you is through those means. And they're saying that's the only way they can identify you. And we need that social security number because you have to provide that to us so we can check your credibility and all this type of stuff and da 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 and identification. So let's look at this document. Look at this law. So this is 408 dealing with penalties. You can read the rest later, but this goes here, right? Okay, so 4, having knowledge of the occurrence of any event affecting, let's go back up here. Whoever, it says whoever, okay? Having knowledge of the occurrence of any event affecting 1, his initial or continued right to any payment, the initial or continued right to any payment of any other individual who has say whose behalf he has applied for or is receiving such payment, conceals or fails to disclose such event with an intent to fraudulently secure payment, either in a greater amount than is due or when no payment is authorized. Let's go down to 7. Remember that. Number 7, for the purpose of causing an increase in any payment authorized under this subchapter to be made when no payment is authorized thereunder, or for the purpose of obtaining any payment for any other benefit to which he is not entitled. Remember the word entitled, right? Let's go back here, right? This is what we was talking about. Entitlement. If you're not entitled, right? Willfully knowing and with intent to deceive, uses a social security account number, an account number. It's not a social security number, it's a social security account number assigned by the commissioner of social security on the basis of false information furnished to the commissioner of social security by him or by any other person, or with the intent to deceive, falsely represents a number to be the social security account number. So it goes both ways, right? Assigned by the commissioner, or knowingly alters social security card, but we're not going to worry about that. Number 8, discloses, uses, or compels the disclosure of the social security account number of any person in violation of the laws of the United States, or conspires to commit any offense described in any of paragraphs 1 through 4, shall be guilty of a felony. And upon the conviction thereof shall be fined under Title 18 or imprisoned for not more than 5 years. So what I'm saying is that this is all having to do with our everyday life and providing social security numbers, identification, and all these different things in order to get something that is already supposed to be for us. In order for us to get these things, even to get our lights turned on, we have to do this same process. To even rent, they got to do a credit check on you. They need your ID. They need to run these numbers on you all the time. So remember that. So look at what they got there. Restitution. Right. So we started here. Peonize abolish, right? Any liquidation of any debt or obligation or otherwise of declare null and void. Okay. So this is where we're going with this. Okay. So let's go to the next one. Collection of extensions of credit by extortionate means. What does that mean? Everybody knows what extortion means. Whoever knowingly participates in any way or conspires to do so in the use of any extortionate means to collect or attempt to collect any extension of credit or to punish any person for the non-repayment thereof shall be fined under this title for 10 years, 20 years. I know plenty of people who have got calls, mail saying, if you don't do this, we taking that car, we taking that house, we taking this, we cutting that life off, we cutting that water off, we cutting that card off, we cutting all this off. Done. Child support. If you don't pay child support, boom, we're gonna be reporting that on your credit report. We're gonna make sure that you will not be able to operate in the United States in the system and be able to get these benefits and privileges that is for you based on the fact that we are fully in control of your life. And you will be under involuntary service or labor as a peon until we get payment. And in most circumstances, with a car, with a house, you're going to be in that service or labor for 5 to 30 years. Okay. So, so here we go. To collect or attempt to collect any extension of credit or to punish any person for the non-repayment thereof. So if you don't pay it, they still can't do nothing to you. Even if you pay it, even if you don't pay it. Okay. Let's go to the next one. Financing extortionate extensions of credit. Financing extortionate extensions of credit. Whoever willfully advances money or property, whether as a gift, as a loan, as an investment pursuant to a partnership or profit sharing agreement, or otherwise to any person with reasonable grounds believe that it is the intention of that person to use the money or property so advanced directly or indirectly for the person making extortionate extensions of credit shall be fined under this title or an amount not exceeding twice the value or go to jail for 20 years or both. Now, this is a little bit tricky, right? Because if the Constitution states that all debts must be paid in gold and silver, so that means the medium of exchange is gold and silver for payments of debts and transfers and so on and so forth. And we don't have that. We don't have that way of doing it anymore. It has been totally shut off and has been hidden on ways of how to even make transactions in gold and silver. Uh, this maybe. Just think about it. I'm gonna leave it there. Now we have other things, right? I briefly mentioned uh you get mail, right? You get mail. Everybody has gotten some type of mail or something saying, hey, here's a billing statement. This is how much you owe. It's a whole breakdown of all the things that you owe. You got the principal amount, you got interest, it needs to be paid by this day. You see what I'm saying? And if you actually look at the back and other documents that they put with it, they pretty much tell you if you do not pay, this is what's going to happen to you. Now, this is what you consider to be passive aggressive and somewhat deceptive in a state where you say these words and they kind of flowery, but if you actually read them for what they are, it's pretty much a threat. And it could be considered extortion, force. See what I'm saying? Just giving you another way to think about things. This is where you got to have your common sense, because when you use your common sense, you stay balanced and you take it for what it is, not as trying to make it define as something different. This is what the system in dealing with these type of pirates that come in and make offers in the public is they manipulate the words to where they make you believe that you are the one that is actually the one that has all the obligations subject to them, where you eventually start repeating it, right? So, with that being said, these things that come into the mail, a billing statement, not being fully clear on what it is basically telling you that it's under the assumption that you got to pay. And if you don't pay by this time and this amount, then this is what's going to happen. You're going to have penalties. You're going to have this. You're going to have that. You have that. Okay. So you have these things in place. All this is in everybody's everyday life. Now, once we get into the point where we say, hey, you know what? I need you to validate this debt. I need you to validate that you have the rights and entitled to enforce payment upon me. I need you to produce every document that you have on me with your company's name on it that says that we have a contract and the obligation is all on me, and this is what we're doing. And I need to see it in my original wet ink unaltered signature. I need that. And you got 14 days to do it. You got 14 days to do it. Here's why. There it is. Right there. Statement of account. Request means a record. Right there. Record authenticated by a debtor requesting that the recipient provide an accounting of the unpaid obligations secured by collateral and reasonable identifying requesting regarding a list of collateral. Right. Duty to respond to requests. Subject to subsection C, D, E, and F, a secure party other than a buyer of accounts, shadow paper, payment intangibles, or promissory notes, or a consigner shall comply with a request within 14 days after receipt. Now, here's the thing. This is what this is saying. The secure party has to do it, not the buyer of accounts or debt buyers. Buyer of accounts, shadow paper, payment intangibles, promissory notes, consigner, promissory notes, all these things, deeds of trust, these accounts and these credit installment contracts that you retail installment contracts that you sign off on to extend credit in order to get the thing is chattel, payment intangible, promissory notes, consigners. You know what I'm saying? These are the things that people are coming, or these are the ones that are actually the ones trying to execute payment or entitlement and enforce obligation upon you, but they're not the secure party. Why? Because their names are not on none of those instruments. All they did was bot bad debt. The secure party, or the one that's actually the one that's supposed to be in the transaction or could still be a real party in interest, you'll never know who they are. And they keep it over a certain period of time and then they get rid of it like a hot potato. Most of them, they don't keep it for more than 3 years. Some of them, they don't keep it more than 9 months because they already know that it's bad debt. It is an indentured contract. It is in violation of, let's go back. Let's go, let's go back. It's in violation of this. And therefore in violation of this, right? This, this, not this, this, this. Now, once you give them a call, not give them a call, but once you do a qualified written request or a dispute letter or anything like that, you want to use these type of language. Is you don't use the codes, use the language. Provide me you have the rights to, and you are the one that is entitled to enforce this obligation and enforce payment. Show me that you are a secure party and not a debt buyer. You see, those are the things that you want for them to provide. I need that. I need full accounting. I need the wet, unaltered signature. 14 days. I need that. If you don't provide that to me, I need you to cease and desist all collections, or will be considered to be extortion, threat, duress, coercion, intimidation, and an attempt to put me in voluntary servitude and peonage, which is abolished. Strong words. Now, once we get there, they already know that that is criminal talk. Then once we do that, then all these rules, all these codes and laws that I just put up are in play. Then we get to this. We get to this. Title 18, Chapter 7, Peonage, Slavery, and Trafficking in Persons. Peonage. Remember, we just looked up Title 42, 1994. Whoever holds or returns any person to a condition of peonage or arrest, and any person with the intent of placing him or him in or returning him to a condition of peonage shall be fined and in prison not more than 20 years. Let's go to the next one. Sale into involuntary servitude. Whoever knowingly and willfully holds to involuntary servitude or sales into any condition of involuntary servitude, 20 years or both. Now, how does this fit? This fits because if you're selling somebody into servitude, you're selling paper. That paper has a name that resembles your name, not you, but is attached to you, and real property or properties that are in your possession that you're using for your life, your family, and for your living. So if they come after that house or they come after that car, they pretty much did what? Are saying that you are already in involuntary servitude and peonage. You're already in servitude or peonage, whether involuntary or voluntary, like Title 42, 1994 stated. Okay, so you can work it like that. Okay, forced labor, right? So whoever knowingly provides or obtains the labor or service of a person by anyone, by any combination of the following means, by means of force, threat of force, physical restraint, or threats of physical restraint to that person or another person, by means of serious harm or threats of serious harm to that person or another person, by means of the abuse or threatened abuse of law or legal process, or by means of any scheme, plan, or pattern intended to cause the person to believe that if that person did not perform such labor or services, that person or another person would suffer serious harm or physical restraint. And Like all of those play a position because you never know. They're calling law enforcement. They calling the sheriffs to come get you out of the house. They're calling they're calling people with tow trucks to come take your automobile and pick it up. They're using uh, law enforcement to pull you over, pull you out the car, take your automobile, and then put it in impound and sell it. And you never know what might happen. They could break your arm. They could do anything while they trying to force you out and do what they need to do. They can hurt you. They could do anything. This is all considered to be forced labor, right? Right. And all these things are up in there, right? So abusing law or legal process, that's done a lot, right? The system does it. They utilize the laws, circumvent the laws, you know what I'm saying, to make it not run parallel with the Constitution, but to intersect and become in conflict with the Constitution in order to get to you, to put you in forced labor. Now, violation, 20 years. All right, next, trafficking with respect to penal slavery, involuntary servitude, or forced labor. So as you see right here, this is the same thing. It's just saying it a whole different way. Whoever knowingly recruits, harbor, transport, provides, or obtains by any means any person for labor, right? So you're talking about transport, right? So let's say they pull you out the car, they get you all wrapped, they gaffle you up, boom, put you in handcuffs, put you in the car, and harbors you and transport you to the holding cell. Okay. Let's say you're in your home and law enforcement comes, trespassers come through the gate, pulls you out of your house, puts you on the outside, and leaves you there and blocks it all up, and then boom. Or they come and take your car and your automobile, so on and so forth. All these different aspects of doing things. And let's say even and basically you have a bank or a financial institution or some type of shell corporation that are executing these things. You also have what you would call foreclosure trustees, companies, and so on, attorneys that are actually executing these things too as well. The only way you can attack it is saying that this is actually being done. Okay, so there we go. What does that say? 20 years. All right. Sex trafficking of children or by force, fraud, or coercion, right? So in this situation in 1591, right, if sex trafficking could be any type of molestation, let's use the word molestation. Molestation is something where somebody, if an officer puts his hands on you, the bailiff put their hands on you, right? In any of these circumstances, all of them can be tied to that. That is considered molestation. That's a form of sex trafficking. All right. Now, we got one more. Unlawful contact with respect to documents and furtherance of trafficking. Uh-huh. What about these documents? Whoever knowingly destroys, conceals, removes, confiscates, or possesses any actual purported passport or other immigration document or any other actual or purported government identification document of another person in the course of a violation, da 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 da, to prevent or restrict or to attempt to prevent or restrict will without lawful authority the person's liberty to move or travel in order to maintain the labor or services of that person when the person is or has been a victim of a serious form of trafficking in persons as defined by da 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 shall be fined under this title or imprisoned not more than 5 years or both. So this is what this means, like child support. If child support puts a suspension on your passport, they can't do that. Your passport is to freely travel. This is the violation of peonage and Title 42, deprivation of rights under color of law, conspiracy against rights. These things tie together with involuntary servitude and peonage. Just like they take your refund checks from the IRS and the state. They take your refund checks. Now that money was for you and your family, for you to do things, not to make a profit or anything like that, to invest in it and do with it as you please. They just intercepted that. It is Deion Sanders picked it to the end zone. And you have no, well, equal protection, no due process, no taxation without representation, no representation. They're just taking it under the guise of law when it's nothing but deprivation of rights and conspiracy against rights under the color of law, and a form of involuntary servitude and peonage, which has been abolished. So just remember when the next time we do this, we're going to talk about the whole process and how we can possibly enforce this in a way that nobody's really haven't spoke of. Until then.